Good morning, this is your Kelso Report for Friday, December 14th, and I'm your host, Clark Kelso. We begin today with the Ninth Circuit's approval of California's efforts to cut costs in its Medicaid program. And then we look at cases involving equitable tolling in an administrative law context, the statute of limitations applicable to criminal conspiracy charges, and the duty of care owed by architects and engineers in construction defect litigation involving a condominium, where the plaintiffs are, of course, the ultimate purchasers. We'll begin with our Ninth Circuit decision involving the Medicaid program. California, over the last 10 years, has been trying to cut costs in its Medicaid program. And here, in yesterday's decision, we see the difference between judicial review of state action and judicial review of federal administrative agency decisions. And we see the key importance of judicial deference to those federal agency decisions under the Chevron standard. Those differences were on vivid display in the Ninth Circuit's decision in Managed Pharmacy Care versus Sebelius. This case involved just one of many of the continuing efforts by state officials to cut costs in Medicaid by substantially lowering the rates paid to providers. Following the procedure set forth in the Medicaid law, the state had submitted a plan, in this case to reduce pharmacy rates to the federal agency charged with managing the Medicaid program. The federal agency reviewed and approved the plan. Nevertheless, a federal district court had granted a preliminary injunction against implementation of the plan based on an earlier Ninth Circuit decision that had interpreted a key statutory provision of the Medicaid law as requiring a particular methodology in setting rates. In that prior decision, the litigants were only the affected providers and the state, and the federal agency did not have an opportunity to offer the court its own interpretation of the federal statute. Well, in the current case, by contrast, the federal agency had approved the state's plan and its cuts, thereby expressing the agency's judgment that the state's methodology was acceptable. Emphasizing that key difference, the Ninth Circuit panel reversed the district court's judgment and vacated the preliminary injunctions, concluding that in light of the Chevron deference owed to the federal agency's decision, the plaintiffs could not establish a likelihood of success on the merits. It looks like California's efforts to cut its Medicaid program finally are going to be given approval by the federal courts. Now we turn to equitable tolling in administrative law. One of the fundamental principles in administrative law is that administrative remedies must be exhausted. That principle can run headlong into the practice of tolling a limitations period in one court while related litigation is moving forward in another court. The First District resolved that conflict in Jorndal versus Penna in favor of the administrative law principle and against equitable tolling. The case involved a decade-old dispute between the plaintiff and his former state agency employer, the Department of Developmental Services. After he was terminated in 2002, he filed an action for retaliatory termination in essentially identical state and federal lawsuits. The state lawsuit was put on hold while he pursued the federal action, twice successfully appealing adverse judgments. That's why it took 10 years. After the second successful appeal in 2011, he decided to switch tracks, and he then filed an amended complaint in the state lawsuit alleging a new single cause of action under the Whistleblower Protection Act. The defendant filed a demurrer on the basis that the plaintiff had not filed a timely administrative complaint on that claim, which is a statutory prerequisite to a civil action under the Act. The Superior Court rejected the demurrer, reasoning that the doctrine of equitable tolling applied, given the pendency of the related federal litigation. The First District reversed as a matter of law. As it pointed out, the equitable tolling cases have all involved a situation where two nearly identical cases are pending in two different courts, and one case proceeds ahead of the other. None of the cases involved pending federal litigation where the plaintiff had failed to exhaust available administrative remedies before proceeding to litigation. And moreover, the Whistleblower Protection Act made the timely filing of an administrative complaint a prerequisite to a civil action, thereby re-emphasizing the importance of administrative exhaustion. In essence, permitting equitable tolling to apply in these circumstances would frustrate a fundamental goal of the exhaustion requirement, which is to give the agency an opportunity to resolve the matter without litigation. Having found equitable tolling inapplicable in this case to extend the deadline for pursuing the administrative remedy, the First District granted the requested writ of mandate and directed the trial court to sustain the demurrer. A big win for administrative law principles over equitable tolling. Now we turn to limitation of actions in a criminal law context. One of the problems that commonly arises when applying statutes of limitations is that two different statutes may appear to cover the same claim or charge. And that was the problem facing the Second District in People v. Milstein, where the defendant had pled no contest to one count of conspiracy to defraud by false pretenses, in violation of Section 182. The only issue on appeal was whether the conspiracy to defraud charge was subject to a 4-year statute of limitations for felony offenses which have fraud as a material element of the crime, or whether a 3-year statute of limitations for criminal conspiracies applied. The First District concluded that the 3-year statute applied, noting that it has long been recognized in California that conspiracy is a distinct and separate crime, which has its own distinct and separate limitation period. Because it was undisputed that the prosecution of the offense was not commenced within 3 years of the last overt act in furtherance of the conspiracy, the action was time-barred, and the conviction was therefore reversed. We close with a construction defect case. The duty to ultimate consumer purchasers of an architect and design professional who provided architectural and engineering services to contractors building a residential condominium was the issue before the First District in Beacon Residential Community Association versus Skidmore, Owings, and Merrill. The trial court had granted demurrers filed by the defendants, concluding that architects who contracted only with the building contractors did not owe a duty of care to ultimate purchasers with whom they were not in direct privity. The court's conclusion was based on California Supreme Court authority, recognizing that accountants did not owe a duty to the general investing public with respect to ordinary audits of a company, the famous Biley decision. Well, the First District disagreed and reversed. Now, you may recall the general common law rule has distinguished accountant liability situations where the only injury is economic loss from construction defect cases involving architects and engineers where the construction defect results in property damage or personal injury. In that context, the common law has imposed a duty of care on architects and engineers. California's legislature in 2002 enacted a series of construction defect reforms, and one of the statutes contains language directly referring to liability for injuries resulting from design and architecture failures. That legislation also abrogated the economic loss rule in the specific context of construction defect litigation. Well, given the general common law rule imposing a duty on architects and engineers of residential construction, and the statutory language enacted in 2002, the First District held that design architects and engineers of residential construction do owe a duty of care to purchasers for construction defects. So it reversed the demurrer granted in favor of the defendants and sent the case back for further proceedings. An important duty case. That's it for the Kelso Report. Have a good weekend and a great day in the law.